Good morning, friends. We'll be starting with the polity static lecture. And the last lecture we covered constitutional bodies. And in this lecture, we'll be covering non-constitutional bodies, Supreme Court, High Court, and the lower court. So we'll start with non-constitutional bodies. In the Dakshmikant, there is Niti Ayog, which is there, but I'll not cover Niti Ayog in this. I'll cover Niti Ayog when I'll teach economics. So I'll be starting with NHRC. And NHRC, as a common sense, is a statutory body. And statutory body, you must be knowing that a statutory body means that it's passed by it's created by the act of the Parliament, unlike the constitutional bodies which which has a provision in the Constitution itself. So, NHRC consists of chairman and 4 other members. And the procedure of appointment of chairman is the most tedious in case of NHRC. So NHRC is appointed by a collegium, white collegium, and that collegium consists of Prime Minister, Leader of Opposition in Lok Sabha, Speaker of the Lok Sabha, Leader of Opposition in Rajya Sabha, Central Home Minister, and Deputy Chairman of the Rajya Sabha. So the collegium appointed or collegium constituted for selecting the chairman of the National Human Rights Commission is the widest in India, and it is considered as a model which should be implemented in the selection of other constitutional and non-constitutional bodies. So we have PM, Leader of Opposition in Lok Sabha, Leader of Opposition in Rajya Sabha, Speaker of Lok Sabha, Central Home Minister, and Deputy Chairman in Rajya Sabha. They come together to select the chairman of the National Human Rights Commission. The chairman, according to its law, the chairman of National Human Rights Commission should be a ex-Chief Justice of Supreme Court, right? And two more members should be at least a High Court judge, or they should be a retired judge of Supreme Court, while 2 other members should have a knowledge of human rights or should have experience with respect to human rights. So we have Chief Justice of ex-Chief Justice of India as a chairman. Then we have 4 members. 2 should be from judiciary, who should have served in judiciary, and 2 should be experts in the field of human rights. Now let's come to the next important trivia with NHRC, and that is that these 4 Rights Commission chairmen, which includes National Commission to Minorities, National Commission for Women, National Commission for ST and ST, and National Commission for ST. These chairmen of these 4 commissions are ex officio members of the National Human Rights Commission. you have to remember one thing, that National Backward Class Commission, the chairman of National Backward Class Commission is not the member of or not the ex-officio member of NHRC. It is only these four: National Commission for Minorities, National Commission for Women, National Commission for SC, and National Commission for ST. Only these four could be considered or is an ex-officio member of the National Human Rights Commission. So the chairman either hold the post for 5 years or till the age of 70, whichever is earlier. So why do we have, other commissions, we have the 65 years as the limit. Why do we have 70 years in case of NHRC? Well, because the chairman of NHRC is ex-Chief Justice of Supreme Court, and he will retire as Chief Justice at the age of 65. So if you want to have 5-year tenure, he should be there in the place till the age of 70. That is very kind of common sense, right? Next we talk about is how they can be removed. How can the chairman be removed? So chairman can be removed under following circumstances. Either he is judged as insolvent, or if he engages during his term of office in any paid employment, or he is unfit to continue because of health grounds, or he has unsound mind, or he is convicted or sentenced to jail for any of the crime. So in addition to these 5, the president can also remove the chairman on the advice of the Supreme Court. So he will have to tell the Supreme Court to conduct an inquiry, and on the basis of inquiry, the President of India will remove the chairman of NHRC. And the grounds for inquiry are proven misbehavior, or it can be incapacity. On the grounds of proven misbehavior or incapacity, the President can tell the Supreme Court to conduct an inquiry, and on the basis of inquiry, if the inquiry found that yes, there is a substance of truth in that, then the President can remove the chairman. Next we come to his functions of the commission. So remember these trivias. First, how he's elected, very important. The age, 70 years. Which of them are ex officio members of NHRC? These are things which you need not to miss. Because when you talk of functions, I think you must be aware of the fact that what are the functions of NHRC. That is something which is very common, right? And that can be got with some basic common sense. Idea is to not miss things which is different and which have little element of trivia in it. So next we come is to the heading which is functions of national human rights. So when we talk of functions of human rights, or when we call function of the commission, so these are the following functions which the NHRC does. First is, it inquires into any violation of human rights. And he can inquire even suo motu, which means without any complaint. If it feels that there is some violation of human rights in any place in India, or it's done by any organization, then he can conduct the investigation suo motu. Secondly, it can visit the jails, and after visiting the jails, it can check the conditions of prisoners, and then it can advise to the government with respect to any improvement. Thirdly, it can review the factors including act of terrorism that inhibit the enjoyment of human rights and recommend the remedial measures. Fourthly, it can intervene in any proceedings involving allegations of violations of human rights pending before the court. Fifthly, it can undertake and promote research in the field of human rights. Next is it can spread human rights literacy among the people and promote awareness with respect to human rights and with respect to protection of rights. And seventhly, it can encourage the NGOs or it can encourage the efforts of NGOs working in the field of human rights. So next we will deal with is the working of the commission. These are things which are very common. I think I even don't need to tell that. I mean, the only thing which I will tell is the tribal issues. Like the tribal issue that it can even conduct investigations suo motu. That's something which you need to read. Other things, if you are preparing for UPSC, you must be knowing that these are things which NHRC will do. I mean, this is something which any commission with respect to that area will do. So my idea is not just you need to mug up things, you also have to use your mind. Some things are common sense, you have to apply the common sense, and through applying common sense you can easily solve 10-15 questions in your exam, even if you would have not read about the topic. Where I am teaching is to things which cannot be solved with common sense, you need to be aware of that. So when we talk of working of commission, we'll see that it has headquarters at Delhi. However, it can establish office in any part of India. So headquarters is at Delhi. Secondly, it has all the power of civil courts and its proceedings have a judicial character. So just like any commission, see, whenever the word commission is fitted with any organization or with anything, anybody, then it means that he has the power of civil court. If you are an IRS and you have assistant commissioner in front of you, it means that you have the power of a civil court in certain matters, right? So anybody which in front of which there is commission, it automatically can be caused that it has the power of civil court in certain matters. Secondly, it can establish effective cooperation with NGOs. These are things which are common. The trivia here is that it can only investigate or inquire into cases which are less than 1 year. Which means that if the case has or the violation of human rights has been done 1.5 years back, in that case NHRC will do nothing. NHRC says that if the incident has taken place, you should come to NHRC within 1 year. If you come beyond 1 year, then we will not help you, then that is your fault that you kept your mouth shut for 1 year. That is your fault. This is a trivia which you need to remember, that it cannot handle cases of incidents which happened more than 1 year ago. Next is the role of the commission. See, my idea is again to only teach you things on which question could be asked in the exam in every chapter. So when I teach you a chapter, my mind is only focusing on how UPSC can make question from this chapter. So I will teach you only relevant things. Certain factual things are there in the chapter. You can read it, you can go through it quickly, but that is not an important, with my experience I can say, it is not important for the exam. So for your own satisfaction, you can go through it quickly. So when we talk of role of commission, we have to find that the recommendations of NHRC are just advisory in nature. Which means that it is not mandatory for the government to accept the recommendations. So it has no power to punish the violator of human rights. It can just recommend that to the government that he should be punished for 3 years. But he cannot, NHRC cannot do it itself. Secondly, it has no power to give award or relief to any victims of human rights violation. It can only advise or suggest the government that this guy should be paid 5 lakhs or 10 lakh rupees. Next is, the recommendations are not binding on the government, but generally government accepts the recommendations of the NHRC because somehow there is this clause in the act which says that you have to tell the parliament why you have not taken action on the recommendations of NHRC. So this ends the chapter of NHRC. There are certain factual things which are there. You can read it from the book. Not important from for the exam perspective. Next is State Human Rights Commission. Here also things are very same, just like NHRC. Only thing is that in case of appointment of the chairman, or the chairman should be retired Chief Justice of High Court. Right? And the two other members should be a serving or retired judge of High Court or District Court, right? So in that case, in the NHRC, the clause was he should be serving or retired judge of Supreme Court or High Court. In this case, he should be serving or retired judge of High Court or District Court. And two other members are someone who have worked in the field of human rights. The chairman and the members are appointed by the governor on the recommendation of committee consisting of chief minister as a head, speaker of legislative assembly, the state home minister, and the leader of the opposition. And in states where there is legislative council, we have the chairman of the council and the leader of the opposition in the council, who are the members of the committee. Now there is one small trivia here. And this trivia is that in case of National Human Rights Commission, the committee consists of deputy chairman also, right? Deputy chairman of the Rajya Sabha. But in case of State Human Rights Commission, the committee will consist of chairman of the council, chairman of the legislative council, which is in house equivalent to the Rajya Sabha of the center. Because the chairman of Rajya Sabha is vice president. So vice president is not part of any of the committee. But here the chairman is not the vice president, right? So here it is the chairman of the Legislative Council who is part of the committee, and in the National Human Rights Commission, it is the deputy chairman of the Rajya Sabha. Secondly, everything is same, but only thing is that you have to use your mind. So there in the National Human Rights Commission, you had retired CJI of Supreme Court, who was the chairman. In this case, it's retired CJI of the High Court. In that case, in NHRC, the two members were from the field of law, and they should have been retired or serving Supreme Court or High Court judge. Here, you have two members who are serving or retired judge of High Court and District Court. Rest everything is same. Yes, one thing is there, one trivia is here, which I just forward, and that is very important. That is most important part of this chapter, which is that even though the chairman and the members are appointed by the governor, however, they can only be removed by the president, and the manner is same as the NHRC president and members are removed. So members are appointed by the governor but removed by the president. Next is Central Information Commission. So when we talk of Central Information Commission, we again know that it's not a constitutional body, it's a statutory body. And it came into existence after the passing of RTI Act. And first thing again, just like the any body, first thing we study is selection process. So he is appointed by a collegium which consists of Prime Minister, Leader of Opposition, and any cabinet minister appointed by the Prime Minister for this purpose. So not the Home Minister, Prime Minister, Leader of Opposition, and any cabinet minister appointed by or nominated by the Prime Minister. And who should be the CIC? Is there any ground for qualification? So according to the Act, the CIC Commissioner, Chief Information Commissioner, and other commissioners should have a wide knowledge and experience in law, science, arts, technology, social service, management, journalism, mass media, administration, and governance. But unfortunately, since its initial starting, we have never had a non-bureaucrat CIC. So even though the Act clearly says and you can select the CIC from many of the other areas, but we have never given non-bureaucrats chance to head the CIC. One more kind of constraint in the appointment is that the CIC should not be a member of parliament and he should not be associated with any of the political party, and the reason is to maintain neutrality. Next we come is to terms and tenure and service conditions. So when we talk of tenure, so the tenure of CIC is 5 years. 5 years or 65 years, whichever is earlier. So most of these bodies, they have the age limit is 65 years or 5 years, except the NHRC, which has 70 years. Now, how can he be removed? So he can be removed by the president on the same grounds as the NHRC chairman can be removed. Same grounds, which is 5 criteria are there, and other than that, on the case of proven misbehavior or incapacity, he can be removed. Next we talk is powers and functions of CIC. So when we talk of powers and functions, the powers or functions are very common, which you should be knowing. I mean, CIC is not a, it's not a, so this and the, yes, the powers and functions are similar, and it's very common. You can read it from the Lakshmikant book. Not anything, I mean, nothing is trivia here. Everything is very factual, and therefore I think there is no need to me to focus on that. It's same that he has a power of a civil code during certain cases. He has a suo motu power of investigation also. He can, I mean, anybody can approach the CIC when he's denied information, when he thinks that the fees charged is unreasonable, when he thinks that the information given to him is false, when the information is not given within the specified time, he can approach to the CIC. Next we have is SIC, or State Information Commission. So everything is same in the State Information Commission as we have in the CIC. Nothing is different, and that is why once you read CIC, you don't need to read SIC. Only thing is that you have to apply the logic. They are Prime Minister, here is Chief Minister who heads the committee. Next we talk is Central Vigilance Commission. So Central Vigilance Commission, when it was established as an executive body, which means it was neither a statutory body nor it was a constitutional body. It was established by the order of the cabinet. But later in 2003, the parliament passed an act, and then it became a statutory body. So first we'll deal with is the composition of CVC. So if a question is asked in the exam that CVC was a statutory body since beginning, then you have to mark it wrong, because it was, for 40 years it was just an executive body. Later it got kind of converted into statutory body. So CVC is a multi-member body, just like CIC, and there is a chairperson, and there are two more vigilant commissioners. So it consists of 3 members, one CVC or the Chief Vigilance Commissioner, and 2 Vigilance Commissioners. Now, how are they appointed? So there is a committee which consists of PM, Leader of Opposition, and Home Minister. And this committee decides on the selection procedure. So you have to differentiate with it with CIC. In case of CIC, we have the committee of PM, Leader of Opposition, and any cabinet minister. And in case of CVC, we have PM, LOP, and Home Minister. So these small trivia you need to understand, you need to remember, because a question is asked on these lines in the exam. Next thing we'll deal with is the tenure of CVC. Now here also there is small trivia that unlike the other commission members of the chairman, the tenure of CVC is just of 4 years. So here you can make a mistake if a question is asked if you have not read this chapter. You will, if a question will say that 6 years and 65 years, 6 years or 65 years, whichever is earlier, you would definitely think, yeah, it's practical because everyone is elected for 6 years, so that's it. So that's why it's right. But unfortunately, in the case of CVC, he is not appointed for 6 years, he is only appointed for 4 years or 65 years, whichever is earlier. Right? Now, how can he be removed? So he can be removed on the procedure is same as that of CIC, as that of NHRC, as that of UPSC. So there are only two bodies. There are only two main bodies which can be impeached, just like the Supreme Court judge. They are CAG and Chief Election Commissioner. CEC and CAG are impeached. They are not removed by this procedure. Rest all of the constitutional bodies and most of the non-constitutional bodies, the procedure is same. President will tell the Supreme Court that I have received complaint that this guy there is strong doubt for proven misbehavior or incapacity. You inquire and you give us the report. And the Supreme Court advise and give the present report, and he has to accept the recommendation. The procedure is same. Next next thing we will deal with is functions. Functions of CVC. So when we talk of functions, the main function of CVC is to inquire or investigate in a case where a public servant who is an employee of central government has committed any offense under the POCA. So main function is to investigate in cases where a public servant who is an employee of central government is said to have committed a crime under POCA or Prevention of Corruption Act. Right? Next function of CVC is to inquire into those officials who are involved in POCA and who are members of All India Service of the Union or Group A officers of central government. Secondly, it exercises superintendence over the functioning of Delhi's special police establishment in cases which are related to POCA. So it exercises, in common word, it means that it exercises superintendence over CBI, because CBI, as you know, has wide variety of functions. So when CBI is doing investigation with respect to case related to POCA or Prevention of Corruption Act, in that case, the CVC exercises superintendence over CBI. So CBI is involved in murder case also. CBI is used for terrorism case also. In all other cases, the CVC does not exercise superintendence over CBI. Only when CBI is conducting investigation with respect to POCA or provisions related to POCA, only in that case, the CVC exercises superintendence. Next function of CBI or CVC is to review the progress of investigation conducted by CBI into offences alleged to have been committed under the POCA. It's the same. Next we have is to tender advice to the central government and its authorities on such matters as referred to him. Next is to exercise superintendence over the vigilance administration in the ministries of central government. So every ministry, every department of central government has one officer known as Chief Vigilance Officer. So the role of CVC is that all the CVO directly reports to CVC. So CVC exercises superintendence over those CVOs in all these departments. Next important function of the CVC is to undertake or inquire into complaints received under public interest disclosure and protection of informers' resolutions and recommend appropriate action. So you must have read about this whistleblower. So this whistleblower, in interest of public, and if he thinks that mass injustice or mass corruption is being committed in his department, then what it can do is that he can write an anonymous complaint to the CVC, and the CVC, based on that complaint, it can inquire, and based on an inquiry, it can recommend an action. Next and very important thing is that central government is required to consult CVC in making rules and regulations governing the vigilance and disciplinary matters with respect to the central services and all India services. So central government will have to take advice of CVC. Next very important thing is that the CVC is involved in selection of CBI director and enforcement director or enforcement directorate director. So the director of ED and the director of CBI is involved, the CVC is involved in the selection process. What is the selection process? We will discuss in the CBI chapter. Now next thing is jurisdiction. What is the jurisdiction? So when we talk of jurisdiction, so all the members of All India Service all the members of Group A service of central government. So it generally deals with Class 1 officers only. And that is why it has been criticized, because this jurisdiction is very low. Secondly, it can investigate into the matters of officers in the rank of scale 5 in the PSB, which means very high officers. Thirdly, it can investigate in the officers in the grade D and above in RBI and NABARD and SIDBI, again very high officials. CEOs and executives of board in PSUs, managers and above in general insurance companies, senior divisional managers and above in LIC, and officers drawing salary of 8,700 per month and above on central government. So only high officials are under the jurisdiction of CVC. So just like I've already told you that every commission has civil court power. So CVC also has civil court power, and the central government and its authority shall consider the advice of CVC and take appropriate action. That is also in the law. And if the central government does not agree with the advice of CVC, it shall communicate the reason in writing to the CVC. So the central government will have to communicate in writing to the CVC why it is not accepting the advice or the recommendation. Then next is all other things are similar, same, not anything is different. Next thing next non-constitutional body which we'll discuss is CBI. So CBI, as you know, was set up in 1963 by a resolution of Ministry of Home Affairs. So it is neither a statutory body nor a constitutional body. It is an executive body. And it was an irony that two executive bodies in India, the Planning Commission and the CBI, were and they are the most powerful bodies in India. That is an irony. In a democracy, you have given so much power to two non-statutory and non-constitutional bodies. So the CBI gets its power, it derives its power from Delhi Special Police Establishment Act 1946. So this is from this act that the CBI derives its power. So CBI was established on the recommendation of Santhanam Committee. While CBI was with Ministry of Home Affairs earlier, but trivia is that now it is with the Ministry of Personnel. It is under the Ministry of Personnel. It is not under the Ministry of, or it is not under the Home Ministry, which many people think. It is under the Ministry of Personnel. Next we talk is the composition, or next we talk is the division of CBI. So CBI is, as we know, is a multi-dimensional body because it is not involved in just one area. It is involved in multiple areas. So it is involved in combating corruption in public life, in economic crimes, in dealing with economic crimes, dealing with cyber and high technology crimes, in supporting state police organization and law enforcement agencies in national and international cooperation. It plays a leading role in war against national and transnational organized crime. It also focuses on upholding human rights, protecting environment. This is something which, if it will come in the exam, you will mark it wrong because you think it's not related to CBI, but it is related to CBI. Next is, these all are part of vision of CBI. Next is developing a scientific temper, humanism, and spirit of inquiry and reform. Now, these things are very important because if you don't read them, you will mark it wrong in the exam because you will think that how can the vision of CBI contain developing scientific inquiry? How come they become so Nehruvian? And that's why you could mark it wrong. That's why you must read these things, very important for the exam perspective. Next we deal with is the composition of CBI. So CBI is headed by a director. It is headed by a director. And how is director appointed? So director of CBI is appointed by central government on the recommendations of a committee consisting of CBC as the chairperson, the vigilance commissioners, the secretary to the Government of India in charge of Ministry of Home Affairs, which means Home Secretary, and one more secretary in the Cabinet Secretariat. So these are the people who are on the basis of whose recommendation the director of the CBI is appointed by the government. So CBI has, with the enactment of CBC, the Superintendence of Delhi Special Police Establishment Act vests with the central government. And next we'll deal with is the functions of CBI. So CBI is involved in multidisciplinary functions like investigate cases of corruption and bribery, investigate cases related to infringement of fiscal and economic laws, serious crimes, terrorism cases, maintaining crime statistics. Only thing you need to remember is that when it is dealing with corruption cases under the POCA, it is under the authority of the CBC. In rest of the cases, it's different. It is not under the authority of CBC. So this ends the non-constitutional bodies that we'll deal with. Next thing we'll deal with is the judiciary. So in judiciary, we'll first start with Supreme Court. So Supreme Court normally sits in New Delhi. However, it is nowhere written in the Constitution that it cannot sit anywhere in India. So only thing Constitution says is that it sits at New Delhi. Next is, how is CGI appointed? So the CGI is appointed, there is no procedure laid in the Constitution of India with respect to appointment of CGI. There is nothing is written in the Constitution which says that CGI is appointed with any proper or any procedure. But starting till 70s, as you know, it is the government which used to decide who will be appointed as CGI. Usually it was by seniority basis. Later, after the first, second and third judge case, the Supreme Court established a collegium, and in that collegium there were Chief Justice of India and there were 4 more senior judges, and that collegium technically decides how the judges are appointed. However, the CGI is appointed based on the seniority right now. So any judge which is the most senior judge and which has time left, because you have to retire at 65. So if somebody becomes the most senior judge at 64 years, 8 months, then automatically he will be CGI for next 4 months. Next we talk is appointment of other judges. So other judges are appointed by the President after consultation with the collegium, and that collegium consists of Supreme Court Chief Justice of India and 4 most senior judges. Based on their recommendation, the President the President appoints the other judges. Next we have is the qualification for the appointment of judges. So when we talk of qualification, so he should be at least a judge of High Court for last 5 years, or at least he has been an advocate of High Court for last 10 years. If he has these two, and third thing is that in the opinion of President, he should be a distinguished jurist. Who is a jurist? Jurist could be a professor of law at any, like Faizan Mustafa, if you must have been aware of. He comes in, he frequently comes on NDTV. He could be called a jurist because he is an expert in the field of law. He is a professor of law. Therefore, there are 3 qualifications. Age is not a qualification. You can be judge of Supreme Court at 40 also. So age is not a qualification. Qualifications are only 3. You should be judge of High Court for 5 years. You should have been advocate of High Court for last 10 years. Or you should be a distinguished jurist in the eyes of President. Next we have is appointment of Chief Justice. Next we have is tenure. So Chief Justice has a tenure of 65 years. and the minimum age is not there. So he will be retired when he will be 65. Next we come is the process of removal of judges. So just like president, the judge can be removed by an impeachment. However, the process is little different. So when we talk of Supreme Court, or when we talk of removal of judge of Supreme Court or the Chief Justice, he could be removed on two grounds. One is incapacity and other is misbehavior. So what is the procedure? So the procedure is that a motion will be signed by at least 100 members of Lok Sabha and 50 members of Raj Sabha. If Raj Sabha is signed, 50 members of Raj Sabha. And after this motion is signed, the speaker may consult such person as he thinks is fit, and consider such material as may be available and may admit the motion, or he may also refuse the motion. So after the motion is admitted, a committee of 3 persons will be appointed. And that 3-person committee, in that 3-person committee, one person should be the CGI or the judge of, if the impeachment motion is against the CGI itself, then other judges. So it should be CGI or judge of Supreme Court. Second person should be a CGI or judge of High Court. And third person should be a distinguished jurist. So these three member committee would be formed, and this committee would inquire that whether there is any substance in the in this motion, and it will then recommend to the president, or it will recommend to the speaker, and after that the parliament will sit and vote. And how will they vote? They will have to pass, or they will have to ratify it with 2/3 majority present and voting, and majority of the house. Now, understand this thing, it's very important for the exam. There is a little difference between how the president is elected, how the president is removed, and how the CGI and the other judges are removed. In case of president, you require 2/3 majority of the house, of the total strength of the house. So if the strength of the house is 552, so the total or 2/3 majority would be what? It would be around 340, something around that. So you require support of these many people in order to impeach the president. While in case of CGI and the other judges of Supreme and High Court, you require 2/3 majority present and voting, which means that if there are 400 people, so around 280 people should support the motion, plus that number should be more than half of the total strength of the house, which means if there is 275 is a middle way, then if 276 people support the motion in Lok Sabha and Rajya Sabha, then it means that the judge could be impeached. So remember this small, basic but very trivial difference. In case of president, full majority or the majority of the strength of the house is required, while in case of judge, only the majority of the strength of house is required, or what you call a simple majority. Next we'll deal with is a provision of appointment of ad hoc Chief Justice. So when we talk of ad hoc judges, sorry, not ad hoc chief justice, ad hoc judges. When we talk of ad hoc judges, we'll find that ad hoc judges mean, so Chief Justice, with the previous consent of the President, can ask a High Court judge, after consulting the CJI of that High Court, to attend at the sitting of a Supreme Court as an ad hoc judge. Right? So what is the provision? That the CJI, with the permission of President, or with the previous consent of President, and with the permission of the Chief Justice of the High Court, can appoint any judge of High Court as an ad hoc judge of Supreme Court. And when that ad hoc judge is appointed, he has all the powers and privileges of a judge of a Supreme Court. Next is attendance of the retired judge. So Article 128 deals with that. And again, the Chief Justice, with the prior consent of President, can request a retired judge of Supreme Court or High Court who is qualified to become judge of Supreme Court, to act as a judge of Supreme Court. So there are two things. One is ad hoc provision, ad hoc judges. Second is using of retired judges. So difference here is that in case of ad hoc judge, that judge is already serving. While in case of retired judge, he has already been retired. So when he is retired, he can be appointed as a acting judge. However, and he has all the jurisdiction and powers and privileges of Supreme Court, but he shall not be deemed to be judge of the Supreme Court. He is not deemed to be judge of the Supreme Court. Next we have is acting CG and ad hoc judges. So acting CG is appointed by President if the CG is ill, or he went out, or he's not in the position to serve. Next we have is independence of Supreme Court. So independence of Supreme Court is, it's very common that because of the strict procedure we have in terms of the removal, the salaries, the pensions, the allowances are not charged from the are charged on the CVI, and they are not subjected to vote. These are the reason why, and these are the reasons which are given to make the Supreme Court independent. Next we have is the jurisdiction and power of Supreme Court. So when we talk of jurisdiction and power of Supreme Court, it has various kinds of jurisdiction. First is original jurisdiction. So when we talk of original jurisdiction, we mean that case will come to Supreme Court in the first instance. So it is not appealed from lower court. It comes to Supreme Court directly. So these are cases which are purely federal in nature. So these cases include when there is question or when there is dispute over a question of law between union versus states, or states versus states, one state versus another states, or government of India and one state at one side versus other states. So in all these cases, the case is directly when it goes to the Supreme Court. Next is when there is, in case of disputes of election in VP and Vice President election, when there is dispute in the election process of VP and President of India, then the case directly goes to the Supreme Court. So election related disputes. Also, one more type of original jurisdiction of Supreme Court is the writ jurisdiction. But this is not exclusive. These are all the top are exclusive. Understand the difference. Exclusive means that it is only dealt with Supreme Court. It cannot be filed in High Court. But this writ jurisdiction is original, but it's not exclusive. Because you can also file the writ with respect to enforcement of fundamental right in the High Court also. Right? So it is not exclusive. It is original, but it is not exclusive. All the four other cases, the Supreme Court has a complete original and exclusive jurisdiction. Next type of jurisdiction of Supreme Court is appellate jurisdiction. So appellate jurisdiction means that the matter comes to Supreme Court on the basis of appeal from the High Court and the lower court. So when in terms of appellate jurisdiction, there are three kinds of matters. There are four kinds of matter, I would say. First is constitutional matter. Second is civil matters. Third is criminal matters. And fourth is SLP or special leave petition. So constitutional matters, when we say constitutional matters, so appeal lies to Supreme Court if the High Court certifies that the case involves a substantial question of law as to interpret the Constitution. So High Court has to certify that the case involves a substantial question of law as to interpret the Constitution. Second matter is civil matter. So again, appeal from Supreme Court lies if the High Court certifies that the case involves substantial question of law of general importance. And in the opinion of High Court, the said question needs to be decided by Supreme Court. Third is criminal matter. So in this case, the appeal lies to the Supreme Court if in three categories. Firstly, if High Court has sentenced someone to death. Secondly, if High Court has withdrawn for trial before itself a case from lower court, and in such trial, the lower court has sentenced the accused to death, which means that the High Court has taken the case from the lower court, and the lower court has announced death in that case. And thirdly, if the High Court certifies that the case is fit for appeal to Supreme Court, even if High Court on appeal has reversed an order of acquittal of the accused and sentenced him to death or life imprisonment for the period of not less than 10 years. So in this case, even if the High Court certifies, if the person is acquitted by the lower court, then the party kind of appeals in the High Court. The High Court reverts that acquittal and sentences that guy to death penalty or more than 10 years of case. Even in that case, the High Court can certify that the case is fit to be appealed to the Supreme Court. One trivia is that appellate jurisdiction is not applicable in cases of court-martial. In cases of court-martial, the appellate jurisdiction is not. So the case from court-martial cannot come to Supreme Court. It will only go to the President of India. Fourth way is special leave petition. Now Article 136 says that. So special leave petition is a confused word, but it means, or under this, Supreme Court has been given power to grant special leave to appeal from any judgment, decree, sentence or order of any court or tribunal except the military tribunal, and it can accept that as a matter of right. Let's understand the concept in a simple language. So suppose after the High Court has sentenced me, I am a murderer, and I have been sentenced 7 years of, or I have been sentenced death penalty, or 7 years of jail. I can file a special leave petition to Supreme Court, and I would say that injustice is being done to me, and please hear my case. Then the Supreme Court has it has a power to accept my SLP because it feels that there is some travesty of justice which has taken place to me. So he can take, without the High Court certification, in all the cases which we have dealt till now, High Court has to certify, right, that the case is fit to go to Supreme Court. But the special leave petition gives the power to the Supreme Court to take the case or to admit the case within its court without the certification of the High Court. And usually it was expected that SLP will be used in very rare cases when there is real travesty of justice. But during last few years, Supreme Court has been using SLP quite frequently, and that is the reason why we have so much cases which are bugged, or why so many cases are pending in Supreme Court. One reason is because of frequent use of or frequent admittance of case under SLP by the Supreme Court. Next is advisory jurisdiction. So President can refer to court either on a question of law or a question of fact, provided it is of public importance. So after the Babri Masjid thing, the Supreme Court, the President of India had told had sent the application to the President, so to the Supreme Court regarding their advice. Even after a 2G case, 2G verdict, the President has sent an advisory note to the Supreme Court of India on asking its views. So there are two things in this. First, it is not compulsory if it's complete pure advisory jurisdiction, or if this pure advisory note on these policy matters like 2G, like Babri Masjid. In that case, it is not mandatory for Supreme Court to give advice, right? But there is also a second case, which is that if there is some dispute arising out of any provisions of a treaty or agreement which was executed before 1950. So if that is the case and the President asks for reference to the Supreme Court, in that case Supreme Court will have to give the advice. It is mandatory for the Supreme Court to give the advice. So there are two clauses. One is purely policy matters. In that case, it is not mandatory for Supreme Court to give advice. And second is those disputes which are arising out of provisions of a treaty which was signed before 1950. In that case, if President asks the Supreme Court for reference, the Supreme Court will have to give the advice. It's mandatory for them. Third is revisory jurisdiction. So if the Supreme Court is empowered to review any of the judgment of any court, be it High Court, be it Supreme Court, be it its own judgment. I'll give you an example. We have this Chandrachud, Y.S. Chandrachud, who is the Chief Justice of India. Sorry, who is the judge in India. His father was also the Chief Justice of India, and he gave a judgment in which he said that right to privacy is not a fundamental right. 40 years down the line, his son reversed the judgment of his father and has said that right to privacy is a part of fundamental right. So Supreme Court can review and it can also scrap or amend its own judgments also and the judgments of any other court also. Fourth is that Supreme Court is a court of record. So Supreme Court is a court of record, and the record, all its judgments, they are all kind of registered. They are all there in the court, and that can be any of the judicial proceedings and the verdicts of the court or the Supreme Court has an evidentiary value before any court. Next is transfer of certain cases. So, if the Supreme Court feels that the case involves substantial question of law, then the Supreme Court may withdraw such cases and dispose them itself. Next is contempt of court. So when we talk of contempt of court, contempt is nowhere defined. I mean, what is contempt is nowhere defined in the Constitution of India. But what we have, according to the Supreme Court, we have two kinds of contempt. One is civil contempt and there is criminal contempt. So when we talk of civil contempt, it is willful disobedience to any judge or other process of the court. Willful disobedience. In this case, you are not jailed, you are fined by the court. Second is a criminal contempt. In this case, if you have published any matter or if you have done any act which scandalizes or which tends to scandalizes or lowers the authority of the court or tend to interfere course of any judicial proceeding, in that case, there could be criminal contempt imposed on you. And if there is criminal contempt imposed on you, you could be sent to jail. So this is all about Supreme Court. Next we will deal with is the High Court. So we start with the High Court. So first thing we will deal with is the tenure of the High Court judges. So maximum age is 62 years. In case of Supreme Court, it's 65 years. So in India, the first High Court came into existence in 1862, and they were set up in all the presidency towns, which is Calcutta, Bombay, and Madras. After the organization, at present we have 26 or 24, you can check the number, because few new high courts have been established in Northeast India, and that is your task to see which new states have high courts. That is an important thing. Only union territory which is high court is Delhi. Except Delhi, no other territory has its own high court. And also high court, according to the Constitution of India, provides for high court for each state, the original constitution, But the Seventh Amendment, 1956, said that High Court, there can be High Court for two and more states. So one High Court can deal or can serve the two or three states. This is what the Seventh Amendment 1956 told. Next we come is the organization of High Court. So the Constitution of India does not mention the strength of the High Court. It leaves it to the High Court itself. It leaves it to the President to decide about the strength of the High Court. So naturally, every state has its own strength according to its needs. Next we come is to the appointment of High Court judges. So High Court judges are appointed in the same way in which the judge of Supreme Court is appointed. So he is appointed by the President of India, and Chief Justice is appointed by the President after the consultation with the Chief Justice of India and the Governor of the state. So Chief Justice of High Court are appointed by the President on the consultation of CGI and the Governor of that state. Next we deal with is the qualification of judges. So a person who has held a judicial office in India for last 10 years or have been advocate of High Court for last 10 years is eligible for becoming the judge of a High Court. Next is tenure. So the tenure of judges is not fixed. You can be appointed as a judge at any age, but there is a maximum age which is 62 years. Next is the removal of judges. This is again the same. The procedure is same in High Court as that we have in the Supreme Court. Next is transfer of judges. So President can transfer a judge from one High Court to another after consulting the Chief Justice of India. So one High Court judge could be transferred to another High Court judge or another High Court based on after consulting the CGI. So there is also a provision of Chief Justice, and President can appoint a judge of a High Court as an acting Chief Justice of the High Court if the office of CGI is vacant, if the CGI is temporarily absent, or if the Chief Justice is not been or is unable to perform his duties. Next we have the concept of additional and acting judges. So next thing we will discuss is the provision of acting Chief Justice. So acting Chief Justice is appointed for temporary period, or acting judge is appointed for temporary period not exceeding 2 years or more. And it can be done only with the previous consent of the President. Next we deal with is independence of High Court. So it is same as that we have in the Supreme Court. That High Court has the way it can be removed is very tough process of impeachment, and other things are also very tough. Next we have is jurisdiction and powers of High Court. This is the most important part of the chapter. So, just like Supreme Court, the High Court also has original jurisdiction also. So the first kind of jurisdiction is original jurisdiction. So in original jurisdiction, it means, as we have discussed earlier, that it means when the appeal is reached to the High Court in the first appeal itself. So it contains matters related to will, marriage, divorce, company law, and contempt of court. If the matter is related to that, it will directly go to the High Court. Second is disputes relating to the election of members of parliament and state legislation. So in this case also, it will directly go to the High Court. Thirdly, regarding revenue matter, in terms of some amount, it will go directly to the High Court. Fourthly, enforcement of fundamental rights of the citizens. This is original but not exclusive, because even in Supreme Court you can file the writ petition. Fifthly, cases ordered to be transferred from subordinate court involving the interpretation of constitution. These are also part of original court or original jurisdiction. Next is writ jurisdiction. Writ jurisdiction. This is different from the Supreme Court's writ jurisdiction because of number of factors. Firstly, the Supreme Court only hears writ, or only you can appeal writ jurisdiction there, which is related to enforcement of fundamental right. While in High Court, you can file any kind of writ petition, and that can be related to even enforcing any legal right. So understand it. This I am again repeating it because this is very important and you need to understand that in case of Supreme Court, the writ jurisdiction is very narrow. You can only file a case in the Supreme Court regarding enforcement of fundamental right. While in case of High Court, you can file a writ petition for enforcing fundamental right, that is there. Other than that, you can also file a writ petition in the High Court with respect to enforcement of any legal right also. Right? So this is Supreme Court means only for fundamental rights. High Court is that you can file a writ petition with respect to enforcement of both fundamental right and legal right. So therefore, the writ petition of High Court is much higher than or much wider than that of Supreme Court. Next is appellate jurisdiction. Now this is also any case which comes from lower court to higher court comes under appellate jurisdiction. Fourth is the supervisory jurisdiction. So when we talk of supervisory jurisdiction, so High Court has the power of superintendence over all courts and tribunals functioning in its territorial jurisdiction except the military court. So all the courts which are within the territorial jurisdiction of the High Court has the power of superintendence over all those courts. So if it's High Court of Rajasthan, then the High Court of Rajasthan has superintendence over all the courts, small and big, in Rajasthan. Right? Next provision is control over the subordinate courts. So High Court completely controls the lower courts, or what we call as district courts, in terms of many things. First of all, it has an administrative control over the lower courts. So it is consulted by the governor in matters of appointment, posting, promotion of district court or district judges, and also in the appointments of person to the judicial services of the state. So this PCSJ, what you call, in the appointment, in the final appointment, it is the governor asks the High Court with respect with suitability. Secondly, it also deals with the matters of posting, grants of leave, transfer, and discipline of the members of judicial services of the state. Thirdly, it can withdraw a case pending in the subordinate court if it involves a substantial question of law that requires interpretation of the Constitution. And fourthly, its laws are binding on all the subordinate courts within its territorial jurisdiction. Just like the laws of Supreme Court are binding over all other courts in India, in the same manner, the laws of High Court is kind of is binding on all the courts of that state. Next we have is that High Court is the court of record. So when we say it's court of record, it means that it has two powers. Firstly, the judgments, proceedings, and the acts of High Court are recorded for perpetual memory and testimony, and these records are admitted to be of evidentiary value and cannot be questioned when produced before any subordinate court. So they act as a legal precedent. When the case is running, so the lawyer has these judgment with him, and he says that, sir, in 1977 the High Court has said this thing, and therefore this is what I am saying. So it is used for the precedent and other matters. Secondly, it has the power for contempt of court, either with simple imprisonment or with both. Next is that it has the power of judicial review. So he has the power of, the High Court has the power of judicial review. Next we have is subordinate court, and I think nothing is much important in the chapter. Only thing is important, which I will tell orally, is that the appointment, promotion, and posting of district judge is made in the state are made by the governor on with consultation of the High Court. And secondly, when we talk of other judges, the judges other than district judge, their appointment is made by the governor in consultation with the SPSC, or the State Public Service Commission. So this is anything about subordinate. Nothing else is important for the subordinate courts. So this ends our chapter on judiciary. In the next chapter, we will be discussing with the special provisions of the state and other remaining chapters of the book.